Today, we are going to be jumping into another very interesting and novel argument that Jennifer Crumbley's new attorney made on her behalf, why she should have never been charged in this case. She should be acquitted. She should be sent home. And really, it's an injustice by the fact that she is sitting in prison. So we are going to be going through this argument today. We already did a number of videos on some of the other arguments, which are all very interesting and novel. And like I said, like I always say when we're talking about the Crumbley case, is that we really have to think about this carefully, and we really have to get this right. The judges and the justices really have to think carefully and get this right, because if they don't, we are going to be seeing a lot of this pattern and this trend of charging parents with some sort of crime that their child committed. So we're going to be starting to see this trend, and we're already seeing it in Georgia, and now this means some other school shootings, unfortunately. So now our parents going to be charged. And by the way, it's not just limited to school shootings. It can be any sort of crime that the child committed. They can start charging the parent with some sort of crime for not controlling their minor child. So this is a very important issue, which is why we have to be very careful when we are literally making law for the first time right now. This is an issue of first impression. This is the first time that this ever happened in history. So we are going to be jumping into this argument today. It's a very interesting, very novel argument. And we're going to be, like we always do, we're going to be looking at the case law, what the case law has to say about this. And ultimately, I'll give you my opinion about this argument. Before we do, I do want to remind everybody that I am still slated to skate in this ice hockey tournament, which is to benefit a very special charity, very special organization that helps families that were stricken with cancer. If you are able to donate at all, the link is in the description. No amount is too small to help this organization. They're doing really, really special work. All right. So let's pull up this is the motion. And this is actually in the middle of the section that's dealing with duty. Now, remember, we had another video about this idea about duty, whether Jennifer Crumbley had any sort of duty, any sort of responsibility to the children at that school. And we spoke about the special relationship doctrine. We spoke about nonfeasance. We'll talk a little bit about that now, maybe because it's going to come up and we'll remind everybody, but there's a full video about the different aspects of whether Jennifer Crumbley actually had any sort of duty to the children at that school. So we explained all of that, but we're going to jump into just a little bit because it brings it up as the brief goes on. But this part of the brief is arguing the following. Even if we are going to conclude that Mrs. Crumbley did owe some sort of legal duty, and if you can read this all in the title, even if the court were to conclude that Mrs. Crumbley owed a legal duty upon which she could be prosecuted for involuntary manslaughter, like we said, the very basis of involuntary manslaughter is based on gross negligence. Gross negligence means that there has to have been some sort of duty, some sort of legal duty to Mrs. Crumbley. And even if the court would find that there is some sort of legal duty, still, any such duty was suspended under the doctrine of in loco parentis, because her son was under the control and supervision of school officials at the time of the shooting. So you're kind of getting a gist of what this argument is going to be. In loco parentis, which is going to be defined in a minute by the Supreme Court, Michigan Supreme Court, is simply a doctrine which says that if you give over custody of your child to somebody else, definitely a school, well, then this is the argument here, then you therefore do not have any sort of duty anymore with that child. The duty was given over to people or the school that has custody of that child. Now, the school is responsible, but not the parents anymore. Once you hand over your child to somebody else, and that person who accepts responsibility for that child has to take care of that child and take care of that make sure that no one is going to get injured by that child, right? So this is their argument that they're making. So we're going to go through some of this argument. It's not that long, and then we're going to talk about some of the law on this. So even assuming, arguendo, that the negligent parental supervision duty was applicable here, Mrs. Crumbley nevertheless did not owe any legal duty to the victims of the shooting, given that the shooter was under the custody and supervision of the school at the time of the shooting. Because the school officials, Hopkins and Ejac, stood in the shoes of the Crumbleys under the doctrine known as in loco parentis, they, and not Mrs. Crumbley, were the ones who had a legal duty to the victims based on their special relationship. And we'll remember that none of the school officials were charged in this case at all. And that could be bothersome to some people. How can you just charge the parents and not the school, who are trained professionals who actually had custody over the child at this time, the shooter, based on their special relationship? And this is what our Supreme Court recently explained. Our Supreme Court recently explained the doctrine of in loco parentis as follows. And this is a case, look at this. This is in July 29th, 2024. So this just came out recently. So you see that this is not just some old, outdated doctrine that we don't even use anymore. No, this is actually a very current doctrine that the Michigan courts use. So this is what it says. The phrase in loco parentis literally means in the place of a parent. A person in loco parentis is one who has assumed the status and obligations of a parent without a formal adoption. So without formally adopting this child, you are still in the place of the parents that you have certain obligations. We have recognized that at least in a limited sense, the relation of a teacher to a pupil is that of one in loco parentis. So that's exactly, teacher and pupil is in loco parentis. Indeed, this common law doctrine arose in the educational context. See Blackstone, okay, etc. A parent may also delegate part of his parental authority during his life to the tutor or schoolmaster of his child, who is then in loco parentis and has such a portion of the power of the parent committed to his charge, viz. That of restraint and correction as may be necessary to answer the purposes for which he is employed. And then continuing, the power allowed by law to the parent over the person of the child may be delegated to a tutor or instructor, the better to accomplish the purposes of education. This is taken from a case, Doe versus Alpena Public School District, July 29, 2024, a very recent case acknowledging that there is this doctrine of the school or the teacher or the tutor standing in the place, standing in the shoes, essentially, of the parents. So you see that this is a recognized doctrine, so he may be onto something here. Well, let's continue. Here, any duty owed by Mrs. Crumbley was displaced or at least temporarily suspended under the doctrine of in loco parentis while her son was at school. The evidence at trial showed that Mrs. Crumbley was summoned to the school by Hopkins for a meeting during which Hopkins and EJAC expressly told Mrs. Crumbley that she did not have to take her son out of school. We all remember that testimony that they said no, they thought that he should stay in school. They didn't feel that he was at risk. To the contrary, the decision was made by Hopkins and EJAC that Mrs. Crumbley's son posed no danger of risk, that it would be better if he stayed in school around his peers. They actually wanted him to be around other people. Mrs. Crumbley left the meeting at around 10:50 a.m. The shooting began approximately 2 hours later at around 12:50 p.m. At the time of the shooting, Mrs. Crumbley was not at the school and thus did not exercise any control or supervision over her son's actions. The absence of such control, custody, or supervision precludes any finding of a parental duty on Mrs. Crumbley's part to control her minor child. Remember, control her minor child. That is straight out of the language of the restatement, which was adopted by Michigan law and which was in the jury instructions, that if a parent does not control their minor child and that minor child goes and damages or hurts someone, then the parent is responsible. Well, here, once she gave over that custody and control and supervision to the school, well, then how can we say that she should have controlled her minor child? She wasn't even in the room. She wasn't even in the same school. In its instructions to the jury, the court made clear that Mrs. Crumbley's duty was dependent on the jury finding both that A, she knew or had reason to know that she had the ability to control her minor child, and B, that she knew of the necessity and opportunity for exercising such control. That is straight out of the jury instructions. Well, based on the record evidence, Mrs. Crumbley could not, at the time of the shooting, exercise any control or supervision over her son. The school officials, on the other hand, did maintain custody, control, and supervision over the shooter. This observation, so this exact observation of in loco parentis, on the led one of the panel members in Crumbley 1 to question why no charges were brought against Hopkins. So this is exactly this doctrine of in loco parentis had one of the judges who, there was an appeal in this case. We're going to get into the appeal in 1 minute. This is an appeal before the trial. We're going to explain everything. Don't worry. There's an appeal before the trial about probable cause. And when that went up to the Michigan Court of Appeals, one of the judges there, which he's going to see, Judge Riordan, had a problem with this exact doctrine. How can we not charge the school? And how is the prosecutor just charging the parents? People versus Crumbley. And don't worry, we are going to pull this case. So don't worry about it. We're going to pull the opinion. And this is what he said in his concurrence. While a prosecutor has wide discretion in deciding whom to charge with a crime, I note that Hopkins conspicuously was not charged by the prosecution in this case, despite his encounters with the shooter on November 29th and November 30th, the day before and the day of the shooting, respectively. Whoa, well, it really sounds like Judge Riordan has a problem with this. How would they not charge Hopkins, who had interactions with the shooter November 29th and November 30th for 2 days? Judge Riordan Riordan's questioning of why Hopkins was not charged was based on the obvious observation that under the doctrine of in loco parentis, Hopkins and Ejek, not Mrs. Crumbley, were the individuals who had control and supervision over Mrs. Crumbley's son at the time of the shooting. And it was the joint decision of Hopkins and Ejek that the shooter could stay in school with his peers, notwithstanding the events leading up to the meeting. So this is exactly what the defense here is making the argument that, look, this is not our argument. This is Judge Riordan's argument. This is what was bothering him. This doctrine of in loco parentis says that Mrs. Crumbley was never responsible for in this case, and it was only Hopkins and Ejek. Now we're going to see if actually that is really what Judge Riordan was questioning about. But at least this is how the defense attorney is representing the argument or the comment of Judge Riordan. So we're going to see in a minute if that's accurate. Accordingly, even if the duty standard taken from negligent parental supervision claims applied to Mrs. Crumbley, so even if you take that duty and they're trying to play it down and saying, yeah, it's from negligent parental supervision claims, that really has to do with criminal culpability. But even if we were going to take that duty, even if it applied to duty, her duty ceased when she entrusted her son to the supervision of the school. See Estate versus Goodwin, which says, generally, unless the parents entrusts the child to another person who agrees to assume the duty to supervise the child, the parent's duty to supervise continues. See also Murdoch versus Higgins, holding that a duty imposing special relationship. Remember that word, special relationship? We spoke about it in one of our previous videos on Jennifer Crumbley, and we explained that special relationship means that, generally speaking, you're not responsible for the non-feasance, for failing to act. That's generally not required. That's not required for you to get off your couch and do something. Normally, you're responsible for your actions, but your failure to act, to control somebody else, generally you're not going to be responsible except if there is a special relationship between you and that person. So for example, a parent and a child, that's a special relationship, and therefore you have a duty to act. You can't just sit on the couch and say, well, I'm not doing anything myself wrong. No, that's called nonfeasance, failing to act. And when you have a special relationship like a parent and a child, then you are required to act in certain instances. And if you don't, then you're going to be responsible. So this case of Murdoch versus Higgins held that even when you have this duty imposing special relationship, but when it ceases to exist, the duty imposing special relationship ceased to exist when the tortfeasor was no longer under the supervision of the defendant, right? When it ceases to exist when you don't supervise that person anymore. When that person's not under your supervision, then that special relationship ceases to exist. So too over here, when you have a Mrs. Crumbley and her son, and she hands over her son to the school, and now that child, for all intents and purposes, is under the custody and control of that school, well, then there's no more special relationship there anymore between the parent and the child. And therefore, we can't say that her failing to act, her failing to control her minor child. And remember, both of the theories of the prosecution was her failing to do something, failing to lock up the weapon and failing to control her minor child. So they're arguing here, the defense is arguing that this case stands pretty strongly for this conclusion, for this proposition, that once you hand over that child, that you had a special relationship before, you handed that child over to somebody else. Now the school has responsibility over that child, and you do not anymore have any special relationship that would be considered that you have to now act to save other people from that child. Okay. Now, before we move on with this brief, he's going to bring over one other case which helps his cause, but this other case is also very distinguishable, which we're going to talk about also, and the fact that it's from a California jurisdiction. So really, California cases don't really have so much precedential value when we're talking about Michigan. Okay, they can still influence the judge or the Court of Appeals, whatever, but it doesn't have the same teeth as Michigan cases. So we're going to get into it, but we're going to hold off just for a moment. Now, I do want to make one mention, and that is from my research that I've done on in loco parentis. So in loco parentis, generally what you find is that in loco parentis, what it does is that normally a parent is responsible for the safety of their child. So that's something that the parent is, and if you don't provide a safe environment for your child and your child gets injured or hurt or damaged or wounded, then you can be responsible for not taking care of your child, right? You have to take responsibility for your child. So in loco parentis says that once you have somebody else who agrees to take over for the safety purposes of that child, then you are relieved of your duty as it relates to the safety of your child. So, for example, there was a case in which they were trying to charge the father of a child where the child was riding his bike and he got hit by a car. And they were arguing that the father should be responsible because he had a responsibility to have the safety of his child, that his child should be safe and not be riding in the street, for example. So that's an example. But if that parent would to give over the custody of that child to somebody else, then you can't say that the parent should be responsible for making sure that the kid doesn't ride in the street and something bad were to happen to the kid. You can't say the father should have to pay some sort of money damages because the father gave over custody to the child. So generally speaking, where we find the doctrine of in loco parentis, it's usually in that type of context where it's the safety of the child themselves, the child himself or herself, that we're concerned about. Also, another area where we find in loco parentis is where the school or teacher has some more leeway in being able to discipline your child. Meaning, generally speaking, you can't just go over to the child on the street and discipline that child in a very strong and strict way. You don't have custody over that child, and that could even be considered in some instances child abuse. But if you turn over the custody of the child to somebody else, so then that person does, or that school and teacher does have much more leeway in disciplining that child. So that's another area where you find in loco parentis. So that's generally speaking, but now they're trying to extend the idea of loco parentis to say that also there should be no more criminal culpability for the parents. Okay, so that's the idea here. Now, we are going to pull up the case of People versus Crumbley. Okay, now this is the appeal, and what happened here is that initially this case was in district court and it was bound over, right? There was probable cause that was found. They found probable cause, and one of the issues here was proximate cause. Okay, let's not mix up our terms. There's probable cause and there's proximate cause. Probable cause is a burden, which is a very much more of a lesser burden on the prosecution to prove that there's probable cause that this person committed the crime, and therefore he's bound over to circuit court. Okay, so you can still call witnesses, and you can have a whole long hearings about it, and it can go on for a few days. But the point is that afterwards, the judge is going to make a determination whether probable cause was proven, and if probable cause is proven, so then it gets bound over. Now, what happened in this case is that the defense here for Jennifer Crumbley was arguing that the prosecution did not establish probable cause, and the reason that they did not establish probable cause, and again, this was the argument by the defense, was that there's a problem here with proximate cause. Okay, so proximate cause is a legal term to be able to say that that what your actions or your inactions, you should, because of those inactions or actions, that's what eventually led to what happened, and therefore it led to this crime, and therefore you should be held legally responsible. That's essentially what proximate cause is. You caused it. Without your actions, it wouldn't have happened. And because you did cause it, so now we can, because there's a link, so therefore now the question is, are you, there's factual cause, there's proximate cause. Proximate cause just means that now that there is some sort of cause that's linked to you, can we say that that's enough of a cause to hold you legally responsible for this crime? Now, one of the issues here is when there's an intervening cause. And this, if you're following me during the trial, we explained this all during the trial also. If there's an intervening cause that takes over, that maybe if nothing would have happened, if this intervening cause wouldn't have happened, then you definitely would have been responsible. But then something else, some other thing happened after your action or your inaction, and this other cause superseded anything that happened before it. And the idea here is that the shooter intentionally shot people. So you're right, there was maybe some negligence here, or gross negligence on behalf of the parents, that they failed to lock up their weapon. But then what happened was, and this all goes on back to the foreseeability, what happened then is that the shooter got a hold of the weapon and committed an intentional crime. Now, a lot of times when you're dealing with proximate cause, if there is an action of intent, if there's an intentional action, well, then that is going to supersede any causes, and therefore you're going to be left off the hook. So they're arguing here, they're appealing this issue, the proximate cause issue, that there's not enough probable cause that Mrs. Crumbley and Mr. Crumbley for that matter, should that their actions or inactions would equal proximate cause to the death of these students. Okay, I hope that was clear. If you want, you can read this entire opinion. There's a long factual lead up to this, but we're just going to jump ahead because we kind of know the facts of this story. So that was what was being appealed. Okay, and what the judges held, and this is what this opinion stands for, is that here, because you're dealing with a child, and because the parents had business knowing what type of trouble this child was going through, and that he was begging for help. He needed mental help. He needed therapy, and the parents were ignoring him and just telling him to suck it up, and all the evidence that we've heard about and remember about this case. So because the parents had so much knowledge about what could potentially happen if they don't secure their weapon, so therefore the fact that this shooter went and committed an intentional criminal act does not take away the legal responsibility of the parents, which would then mean that they actions or their inactions proximately caused the murder of these students. Okay, that's essentially what the idea is. So now this is the concurrence, which is what was quoted. And again, let's remember what the defense was quoting this concurrence for standing for. He was quoting this concurrence for standing for that this judge, Riordan, had a real problem with not applying the doctrine of in loco parentis, that the school should have taken over as custody for the child, and therefore only the school is responsible. Why wasn't the school charged in this case? Now, we're going to read it, and you can tell me whether, with that background, that's what this judge is actually troubled with. Okay, so here we go. In my view, this drawing, we're talking about that drawing, remember? In my view, this drawing, coupled with the other evidence aptly discussed by Judge Murray in the majority opinion, establishes probable cause that EC's conduct, which is the shooter, on the afternoon of November 30th, 2021, was reasonably foreseeable by defendants. Right? A lot of it hinges on this idea of foreseeability. Simply put, this discrete evidence of considered harm to others distinguishes the situation here from the overwhelming majority of cases in which parents may not and should not be criminally liable for a child's crime. Now, if you read this opinion, you see very clearly, and it's a good idea, by the way, if you want to really understand how they're trying to be very careful about this case and not trying to set a new precedent here that parents are going to be charged, you'll see that in this case, they keep trying to point out why this case is different than any other or many other or most other cases where a child will go commit a crime. They're trying to say how this case is very, very different because the parents had a lot of knowledge. And since they had so much knowledge about what was going on, so therefore it was foreseeable, and therefore, since it was foreseeable, therefore they can be held liable. Now again, are the boundaries going to be challenged? Who knows? But this is what you see that they're very nervous about, because the defense was making this type of argument that this is the first time in history. We can't create new precedent here. Now parents are going to be charged every single day for the crimes that their children committed. So they're trying to distinguish. So this is what they're saying in the concurrence here. Simply put, this discrete evidence of considered harm to others distinguishes the situation here from the overwhelming majority of cases in which parents may not and should not, see how clearly he's saying it, should not be criminally liable for a child's crime. In the absence of such discrete evidence as is before us, the outcome of the instant appeal easily may have been different. Meaning this can be very easily, in many, in most cases, the parents should not be charged. That's exactly what they're saying here. Okay, so this should be an anomaly. Now we'll see. A lot of times prosecutors get overly zealous and they start charging parents, but we'll see what happens. But anyway, this is what the judges at least are saying in this case. But the drawing itself is not sufficient to establish probable cause of proximate causation. While a prosecutor has wide discretion in deciding whom to charge with a crime, I note, and we're skipping the side here, I note that Hopkins conspicuously was not charged by the prosecution in this case, despite his encounters with EC, the shooter, on November 29th and November 30th, the day before and the day of the shooting, respectively. Now, this is exactly the quote that the defense quoted in their brief, but they didn't bring the rest. Okay, so now let's see what the rest is. If the rest seems to suggest that his problem is in loco parentis, well, then the defense is quoting it right. If it doesn't, well, then we just found an error and an argument for the prosecution to argue back. Well, here we go. Although it is not the role of the judiciary to review prosecutorial charging decisions absent rare circumstances that are not present here, so we don't review, as a judicial role, we don't review prosecutorial charging decisions. And since the special rare circumstances where we do is not present here, we're not going to do that. but still he's going to make a comment about it. The preliminary examination indicates that Hopkins only was aware that EC engaged in shooting as a hobby. He did not know that defendants recently had purchased a handgun for EC. Thus, Hopkins did not know that EC, again the shooter, had immediate access to an unsecured handgun at home. It is reasonable that he may have assumed the gun that EC, the shooter, used for his shooting hobby only was accessible by defendants. As a result, while Hopkins perhaps could have inferred that EC contemplated harming others on the basis of the drawing of the body, there is nothing to suggest that Hopkins also knew that EC had the means to effectuate this conduct. This is quite in contrast to the knowledge defendants possessed. In other words, the record suggests that it was far less foreseeable from the perspective of Hopkins as opposed to defendants that EC would harm others that day. So now what is he saying? What he's saying is that since this all hinges on foreseeability, and Hopkins didn't know half as much as what the parents knew, so therefore we can't charge Hopkins. We can't hold Hopkins responsible for this because he had no idea about half the things. He didn't know about all his mental challenges. He didn't know about the gun that was just purchased for him. He didn't know that the gun was unsecured. He didn't know about all that. So he sees a scary painting, a scary drawing by this child, and he has no reason to believe in the world that this person has a gun on him right now. And so therefore, for foreseeability purposes, that's why Hopkins wasn't charged. Is there anything in here that Judge Riordan is questioning this in loco parentis idea? Is he saying that they should have been charged because of loco parentis and Mrs. Crumbley should not have been charged because of loco parentis? No, there's nothing to do with that at all in this decision. And this is just the defense trying to create a new argument, which is, again, it's a very interesting and a novel argument, but to try to blame it on Judge Riordan and try to say that this is all Judge Riordan and this has nothing to do with, this is not my own argument. This is really established already by one of the judges who looked at the facts of this case. No, that's actually not what's going on here at all. So that's exactly what the state should argue back, that Judge Riordan had nothing to do. And in fact, there's no words at all here about in loco parentis, and that wasn't the issue. The issue was probable cause. And since the issue is probable cause and they're discussing proximate cause, and proximate cause hinges on responsibility, so that is why he was discussing how it's different. And he was actually saying it's completely fine that Hopkins was not charged. He's not saying Hopkins should have been charged. Just the opposite. He's saying that Hopkins should not have been charged because Hopkins had no idea about half the things that the parents did. So it's quite the opposite of what the defense is making Judge Riordan's issue to be. Quite the opposite. Okay, so now let's just, for completeness sake, let's go through the next part of his argument. And remember that this idea of a special relationship, I just want to talk about this. I want to touch on this a little bit. This idea that they're citing here, that when you give over your child to somebody else, to the supervision of the defendant, then the duty imposing a special relationship ceases to exist. That, if you look at the cases, has to do with other types of relationships, not a parent and a child, like an employer and employee, that type of special relationship. So once you give over your employer and the employee goes to work for someone else, then obviously the employer has no more any sort of special relationship with that employee anymore. And that's what happened in Murdoch versus Higgins. It had to do with a case where there was an employee one employer A had employee, and that employee went to work for a different employer, and that employee that was working for employer B actually caused harm to a child. Okay, so the question was, can we hold employer A responsible for something? And we said no. As soon as the court said, and this is a Michigan case, that as soon as he gave over as soon as that employee A went into the supervision of employer B, then employer A is no longer responsible. They don't have any sort of special relationship. Now, that's not the case when you have a parent and a child. A parent and a child's special relationship always exists. And in fact, like we spoke about this in a different video, which dealt with this special relationship and this whole idea of duty, is that we saw that there was a case very straight on point called Moy versus Golding. And Moy versus Golding says very clearly, when you do not lock up your gun and you're the parent, then you do have a duty to anyone that child who has mental problems goes and shoots up. They go and murder people, then you are going to be responsible. So this case, Murdoch versus Higgins, is really not so on point, even though they do quote a quote that seems to help them. Okay, so let's just continue to move on. Other jurisdictions have applied the same framework in finding that a parent cannot be held liable for the tortious or criminal acts of her minor son. So I think other jurisdictions have also done this. We're not the first one to come up with this idea. This is also California, where the parent did not observe and was not in a position to control the conduct which endangered the injured party. Robertson versus Wentz. Now, this Robertson versus Wentz, an interesting case, definitely worthwhile to go look it up if you want. But Robertson, he's going to go explain what Robertson is, and I'm going to tell you a little bit more that you should know about Robertson, why it's not really, again, so on point to what happened here. Robertson involved claims against a mother for failing to control her 17-year-old son who killed a man during a robbery of a bookstore. In Robertson, the court noted the general rule that absent a special relationship, an individual owes no legal duty to control the conduct of another person. Applying Section 316 of the Restatement of Section 2 of Torts, the court went on to note that the defendant's mother, like Mrs. Crumbley, had no effective control of her minor son at the time of the shooting. Robertson 187, etc. The ability to control the child rather than the relationship as such is the basis for a finding of liability on the part of a parent. The absence of such liability is fatal to a claim of legal responsibility. Now, this really looks like it's helping out Jennifer Crumbley. Look what it says here. It says the absence of such ability is fatal to claim that they are legally responsible. According to Robertson, the key question under Section 316 asks whether the parent had notice of her son's propensity to commit violent crimes, and if so, whether the parent had physical custody, control, and the immediate authority over her son at the time of the criminal act. In affirming the dismissal of the claims, so in that case, in Robertson, the 17-year-old son committed this murder, and they tried to hold the mother criminally responsible, and the court said, no, you can't hold the mother responsible. Well, there you go. This is your case. If you're the defense, this is your case. You see clearly from California. Again, this is California, so it doesn't really have so much precedential value. It's persuasive, perhaps. You can argue it as persuasive authority, but it's not binding on the courts in Michigan. But they're saying, look, this is exactly what happened in California, and they let the mother off the hook. In affirming the dismissal of the claims, the Robertson court also addressed plaintiffs' claims that the mother, like Mrs. Crumbley, was aware of her son's numerous troubles and yet failed to obtain counseling for the boy. To this point, the court noted only the manifestation of specific dangerous tendencies triggered a parental duty to exercise reasonable care to control the minor child in order to prevent intentional harm to third persons. So now in California, they also adopted the same exact restatement, which says that a parent has to control their minor child so that not to cause harm to third persons. The Robertson court found that not only did the defendant's mother lack specific knowledge of her son's propensity for violence, but also that she did not exercise custody or control over him at the immediate time of his criminal acts. As such, the court concluded that the mother could not be held liable for her son's intentional criminal acts, so it is here. So this is essentially the end of this section of the argument, and they're saying, look, this Robertson case is really seems to be very helpful for the Jennifer Crumbley. After all, that's almost exactly the same. You have a 17-year-old son, and 17-year-old son murdered somebody, and they tried to hold the mother responsible. She's not responsible. And some of these great quotes that they have, which seem to be helping them. Now, if you actually look at the Robertson case, it's very different. You know why? Number one is that actually the child was not even living with her mother at the time. The child was not living in the same house as his mother. And the mother had no idea about any sort of access that he had to a gun. And the only argument that they said is that, well, when she did know about her son, then she should have, got some counseling for her son or something like that. But, he wasn't living in the same house, had no idea whether he had access to a gun or not, and then we're going to try to hold her responsible. Well, in this case, right, Jennifer Crumbley was quite different. They had one son. This one son, she should have known, had some serious mental problems, and she knew about the guns. She knew about his fascination with guns, and she should have known that the gun was not locked up properly or safely. So it's very different, to say the least, between Robertson case. And if you look more about that case, you'll see it's very different than what happened here in the Jennifer Crumbley case. So again, even the Robertson case, which definitely seems to help the defense here, is still not the greatest case. So that really takes us to the end. And really, I think what it comes down to, and one of the main issues I think that they have to think about, and like, if you're the prosecution and you're watching this video, then you got to look up Moy versus Golding, because that case really is directly on point in this case. And if you follow some of the analysis that I did, why the defense's cases are not that great, at least in this argument, it's definitely can help the prosecution. But here's ultimately what the issue is. How much does the parent have to know? In terms of what type of mental problems. In Moy versus Golding, which is the case that really can help the prosecution, there was some serious mental issues with that kid. That kid was in a mental institution, and he had very dangerous propensities. Now, in this case, there's been no criminal history for the shooter. There was, you can argue that there was some mental health issues that he had, but what about dangerous propensities? So this can also kind of get into this splitting of the hairs of how dangerous you have to know that your kid is, so that we can then consider you as the parent responsible. Is it enough, basically, is it enough for you to ignore some level of mental health problems that your son is having? Is that enough to hold you responsible or not? And that's really what this case comes down to. And the question again is, whose responsibility was it to secure the gun? And, she was claiming that she had no idea about the gun, and it was really all her husband's responsibility. He would always take care of the gun. It wasn't really her responsibility. So we don't have to rehash the whole case. But this was, again, a very interesting area of argument of in loco parentis. How far do you extend the doctrine of in loco parentis? So we'll see if this gets some more treatment by the prosecution. We'll see if they do some more research about this, and we'll see what eventually what the courts have to say when you actually cut off the idea, the doctrine of in loco parentis, and when do you say that the parents are still somewhat responsible or not responsible? At what point are the parents not responsible? Things like that. So that's going to be it for now. If you haven't yet, please subscribe, like, and we will see you next time.